Picture this. You walk into a courtroom thinking today is just another check-in. No big deal, you've done this before. The judge asks how you're doing. You say great, and then she pulls out a report. A report that says you have done absolutely nothing. Zero. Not one single requirement met. No drug tests passed, no job proof submitted, no check-ins completed on time, just cocaine and meth while the court waited patiently for you to get your life together. That's exactly where this 20-year-old defendant stands today. And what happens next inside this courtroom is something most people never see coming. The judge doesn't just scold him. She doesn't just warn him again. She stops the hearing mid-sentence, calls a deputy over, and orders him handcuffed right there at the podium. But this hearing doesn't stop at one defendant. Halfway through, a second case walks in. A young mother facing felony charges, a CPS investigation, 3 children not in her care, and a meth habit she's only recently stepped away from. The judge will have a lot to say to her too. 2 defendants, 2 very different situations. One judge who is completely done with excuses. Stay locked in because this courtroom is about to get very real, very fast.
Hello, how are you doing today?
Good, and you?
Oh, I'm doing great. Why do you think you're here?
Compliance hearing for criminal positive.
All right. And what else?
That should be it.
Well, let me just tell you the report I'm receiving on you. All right, and this is what the probation officer is saying to me about you. And how old are you?
20.
All right, you're 20. Since obtaining the probationer's case, when they say probationer, they're talking about you. He has shown 0 to very minimal effort regarding his probation. The probationer has had issues reporting on time, reporting for field visits, testing positive for cocaine and meth, and enrolling or providing proof of employment for any remaining court-ordered programs. The probationer and I have had several discussions regarding his actions and how or what we can do to get back on track, really stressing the small actions, such as simply calling this probation officer within 24 hours after an attempted field visit or taking accountability for his action. The probationer appears to continue to struggle to grasp the severity of his circumstances and what he can do to grow and move forward.
Let's pause right here because this probation report is damning on every single level. The officer didn't say he tried and fell short. The officer said 0 to minimal effort. That's the exact phrase used. Not struggling, not slipping, 0. He missed field visits. He tested positive for cocaine and meth. He didn't enroll in required programs. He didn't even return a phone call within 24 hours. The probation officer had multiple conversations with him about doing the bare minimum, and he still couldn't manage it. Here's what makes this worse. This isn't his first violation. This is his 3rd motion to revoke in this very same court. The judge has told him before, directly and clearly, that he is looking at 10 years in prison. He heard that warning and responded by using harder drugs and disappearing from check-ins. At some point, a judge stops seeing a struggling young man and starts seeing a pattern, and patterns carry consequences that warnings never could.
Forward with his life and the lessons he can learn on his probation path. That's the report that I have on you. The report tells me you are doing nothing. 0. Nada. Why are you doing nothing on this probation in this court other than using drugs?
I have attended 2 out of the 4 classes, and we have had
No, they say you don't even call in.
probably when they come for a field visit.
Yeah, they say you're not doing the simplest of things. And what I can tell you is You've had three
Did you
motions.
catch what just happened? The judge didn't raise her voice. She didn't threaten. She simply turned to the deputy and said, "Place the handcuffs on him, please." That word, please, is deliberate. This judge is calm, controlled, and completely serious. There is no drama in her delivery. That's actually what makes it more powerful. She's not handcuffing him as punishment. She's handcuffing him to send a message that the conversation has officially changed. You've had the warnings. You've had the conversations. Now we're in a different place entirely. And then she brings up something that often gets overlooked in these hearings. She questions whether his mother is actually holding him accountable at home. He claims to work with his mother, but there's no proof. The court can't verify it, and because it can't be verified, it doesn't count. That's a brutal moment. The one support system he leaned on just got removed from the equation in under 30 seconds.
You've had three motions to revoke in this court. So, and I know that each time you came before me, I've told you that you're looking at up to 10 years in the prison. Deputy Laura, could you do me a favor? Could you place the handcuffs on him, please? Each time you come before me, I know I've told you you're looking at doing 10 years in prison. Obviously, your mother is not laying down the law with you at home. They say that you keep saying that you work with your mom, but you don't provide any proof. I can tell you right now, I'm not going to allow you to work with your mom because I don't know if your mom is actually having you work with her. So you are going to ISF. And the reason why I'm sending you to ISF is because you need an attitude adjustment. You understand? Now, if you don't want to sign to go to ISF, you don't have to sign for it. What will end up happening is a motion to revoke will be filed. So which would you prefer?
ISF, Your Honor.
All right. So he wants to go to ISF, and if you could put him in ISF cognitive.
Your Honor, so we, the recommendation was for local ISF.
Okay.
He did complete the state ISF.
Okay.
Are you?
Well,
wanted to
if
go
the
ahead and go
recommendation
with
is local, we can go with the local.
Okay.
Has he been drug tested?
He's on a drug patch, Your Honor.
All right. All right. So you're going to go to local ISF. This is the last time we're going to have this conversation with you following rules. Obviously, your mom is not laying down the law with you. So you're not going to be allowed to work with your mom. You're going to have to get a job with a different employer.
Here's where the
Because if you-
judge asks the question that cuts through everything. Do you want to go to prison? Not as a threat, as a genuine choice being placed in front of a 20-year-old who keeps acting like consequences aren't real. She's telling him, if prison is what you want, I will make that happen right now. An attorney will be appointed and we will proceed. Your call. ISF, Intensive Supervision Facility, is the alternative she's offering. It's structured, monitored, and designed for people who can't stay on track without direct oversight. It's a hard option, but it's not prison, and that distinction matters enormously at his age. The fact that he agrees to ISF tells you he understands the stakes now. Whether he actually follows through is a completely different story, but in this moment, standing in handcuffs, the reality finally seems to be landing. The judge's next words are the ones that should stay with him. This is the last time we will have this conversation.
Because if you get a job with a different employer, that employer, if you don't report, they're not going to pay you. They're not going to call the court and say, oh yeah, he reported for work if you did not. Do you understand?
Yes, Your Honor.
All right. Do you want to go to prison?
No, Your Honor.
All right. If you want to go to prison, I will get an attorney appointed to you and you can go to prison and I'll send you to prison. How old are you?
20 years old.
All right. You're 20. You're going to have to start doing better. Do you have children?
No.
That's a good thing. Probation, this is serious. And I hope I'm getting your attention because we're not going to have a conversation again where you're not doing anything. You understand?
Yes, Your Honor.
Now, is there anything else you need to be successful on this probation?
No, it shouldn't be.
All right. Do not come back here again where you are not doing anything. You understand?
Yes, Your Honor.
I keep an open mind on everything, but we are not going to have any more compliance hearings with you. If I get a
Now the judge does something genuinely memorable. She describes exactly what a warrant looks like in real life, and she does it with the kind of detail that actually sticks. You could be at the grocery store mid-checkout. You could be home watching a movie right at the moment everything is about to be solved. Doesn't matter. They come for you wherever you are. It sounds almost humorous when she says it, but the point underneath it isn't funny at all. She's trying to make probation violation feel real and physical to someone who has clearly been treating it as abstract. Many young defendants think of probation as paperwork, a formality, something that exists on a file somewhere but doesn't touch their daily life until it does. The judge is collapsing that distance. She wants him to feel the handcuffs at the checkout line before they're actually on his wrists. Whether that image stays with him when the hearing ends, that's the real question. And honestly, based on everything this court has already seen from him, what do you think?
report and it appears that everything is in order, a motion to revoke is going to be filed. When a motion to revoke is filed, what ends up happening is a warrant is issued for your arrest, and you will be picked up wherever you may be. You could be at the grocery store in the middle of checking out or have already checked out. You know what's going to happen? Those groceries are going to be put to the side and they're going to take you to jail. If you are at home, they're going to pick you up and take you to jail. If you're in the middle of watching a movie and you're at the part where they're about to solve everything, guess what? If they pick you up during that time, you're going to miss what happens. Do you understand?
Yes, Your Honor.
In this court, probation is serious. In this court, communication is key. And probation officers know that I like for them to communicate with people. And that's why they put in here that they've had several discussions with you regarding your actions. Do you understand?
Yes, Your Honor.
All right.
The first case wraps up and a completely different situation steps into the courtroom. Same judge, completely different circumstances. Celine Briard is being sentenced for felony fraud, specifically possession of identifying information involving 5 or more items. That's identity theft territory. It carries up to 2 years in a state jail facility with up to a $10,000 fine. But what unfolds during sentencing goes far beyond the charge on paper. She is pregnant. She has 3 children already. None of them are currently in her custody. Her youngest is 5 months old. Her 3-year-old escaped the apartment while everyone was sleeping, which triggered a CPS investigation. She was using meth regularly and admits she was still using as recently as 4 months ago. The judge starts asking questions that most courtrooms rush past, not to embarrass her, to understand what's actually happening in this woman's life and figure out what kind of sentence actually means something for someone in this position. Pay close attention to how this judge operates, because what comes next reveals a lot about how she approaches justice.
All right. Good luck to you. 3 CR 1042, State of Texas versus Celine Renee Briard. Can I have parties announced for the record for the state?
Hank Woods to the state, Your Honor.
Defense?
Robert Gaona for the defendant.
Are you Celine Briard?
Yes, ma'am.
How do you pronounce your last name?
Briard.
Briard? Oh, I was doing great. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Briard, I'm showing you what's entitled application for probation. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor, but we're waiving count 2.
Any objection?
No objection, Judge.
Ms. Briard, I'm showing you what's entitled court admonishments. Did you review that with your attorney? Did you understand it and did you sign it in all the appropriate places? In count 1, you're charged with the offense of fraudulent use or possession of identifying information, 5 items or more. That's a state jail felony. Range of punishment is anywhere from 180 days in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
And exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
We'd ask that you would, Judge.
Anything you wish to say on behalf of your client?
Judge, that you follow the plea bargain agreement, allow her to be released today. She can report for any type of appointments that are necessary for completion of probation.
All right. So how many children do you have? All right, excuse me. In this area, you all are blocking probation. She cannot hear, she cannot see.
I have 3 children. I'm expecting.
All right. How old are your 3 other children?
They're 2, 3, and 5 months.
And where are they?
They're with their grandmother.
So how long have they been with their grandmother?
A couple of months, Judge.
Why?
I just had some things going on. I thought it was best for my mother-in-law has custody of my kids right now.
Why does she have custody?
Because I had
I'm sorry, you're gonna have to speak
I
up.
had a CPS case going on because of my son got out of the apartment when everybody was sleeping early in the morning, and so
Is this the 5-month-old?
no, no, ma'am. They're 2, 3-year-old.
Okay. So you have a CPS case.
Yes, ma'am. It's currently about to be closed.
Oh, it's about to be closed?
Yes, ma'am.
So that means if it's about to be closed, that means, and your attorney does CPS work, right? So tell her what that means, counselor.
Judge, what happened was it turned out to be a safety plan, an investigation in which I met the safety placement and she verified everything.
So,
If everything pans out, she knows it will be closed. If not, it could go legal.
and
We
the
looked into it
reason why
further.
they do the safety plans means exactly what it says, safety plan.
Yes, ma'am.
So what's your drug of choice?
I mean, I don't do any drugs right now, but I was using methamphetamines, but I've been sober for quite a while now.
All right, how often were you using meth?
Like maybe every week, every other week. It just depends.
When's the last time you used meth?
Like 4 months.
All right, so that's probably why CPS was involved. When's the last time you had employment?
I was right before I was arrested.
Doing what?
I was doing home health care and working for a hotel at the front desk.
All right, I can tell you right now, I don't allow.
This moment with the home health care discussion is one of the most overlooked parts of the entire hearing. And it's actually important. The judge isn't criticizing Celine personally when she talks about home health care providers. She's identifying a systemic gap. Background checks aren't consistent, hiring standards are loose, and the result is that vulnerable elderly or disabled people can end up in the care of someone who hasn't had the stability or accountability to care for their own children yet. That's not a small observation. It's the judge connecting this defendant's circumstances to a larger pattern she's seen play out before. She also doesn't shut the door permanently. She specifically says, maybe once you get your life together, that could be a good fit. That line matters. It tells Celine that the judge isn't writing her off. She's redirecting her, not discarding her. For a defendant who only completed 8th grade, who is pregnant, who has 3 kids in someone else's care, being told your dream is still possible, just not yet, is actually a meaningful thing to hear in a courtroom.
People on probation here to be home health care providers.
Yes, ma'am.
How far did you go in school?
To the 8th grade.
See, and this is nothing about you, but this is my problem with home health care providers. Home health care providing is turning into West telemarketing. They don't do background checks. They're just letting anybody come in. And maybe I'm wrong for saying this, but they're looking at the bottom line, the dollar line. So I'm being told that they're letting somebody with an 8th grade education who has meth issues, who has 3 children that she doesn't even have custody for them, work as a home health care provider. Thank you, home health care provider people. So that is why I don't let people work as home health care provider. Now, maybe once you get your life together, maybe that will be a good fit for you, but I'm not going to allow that.
Yes, ma'am, I understand.
So why do you only have your 8th grade education?
I just never furthered my education, but I am in, actually, just before I got arrested, got some GD books from the library, so I am trying to pursue my GD.
Okay. So what are you planning on doing with your rest of your life? What are your hopes, your dreams?
Well, after I get my GD, I want to be a cosmetologist. So.
Okay. Hey, that's doable. But I will tell you this, anything that requires a license, when you have convictions, before you start spending all that money to do it, You need to find out from the state, wherever you're going to be licensed, if that's going to be a hindrance to you.
Yes, ma'am.
Not saying that it will stop you, but it may cause complications.
Yes, ma'am.
All right, counsel, is there anything else?
Oh, yeah.
All right, this is what the court is going to do. The court is going to sentence you to 2 years in the state jail facility, suspended and probated for 4 years. There's a $500 fine that will be probated. There's to be 200 hours of community service restitution. I'm going to ask for parenting classes, probation, whatever parenting classes you deem would be appropriate for her. Obviously, it needs to be intensive, because for them to say that
Now the sentence comes down and it's worth breaking apart exactly what the judge is ordering. 2 years in state jail, suspended and probated for 4 years. That means she doesn't go to prison today, but she is now on a 4-year leash. $500 fine, also probated. 200 hours of community service. Restitution to the victims of the fraud. Intensive parenting classes. Drug evaluation and treatment if recommended. No contact with one specific individual. No unsupervised contact with minors. Proof of employment within 30 days. No working in home health care. That is an enormous list of conditions, and every single one of them has a consequence attached if skipped. The parenting classes being marked as intensive is a direct response to the CPS case. The judge isn't guessing at what Celine needs. She's reading the file and building a sentence around the specific failures that brought her here. This is what individualized sentencing looks like in real time. Whether Celine can actually carry all of this while pregnant, with 3 kids in someone else's home, and a drug history still fresh, that's the real test starting today.
that the children are to remain where they remain, that means that she didn't do any. So I'm going to want intensive. There's to be restitution and no contact with Juan Palomino. There's to be no unsupervised contact with minors. There's to be proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. The UA hotline until further notice. Field visits 1 time per month until further notice. TAP evaluation in custody. Follow all TAP recommendations. If TAP is recommending outpatient treatment, then I'm going to want intensive outpatient treatment. If they are recommending inpatient treatment, then she can do intensive treatment and do a referral to felony drug court. I know that felony drug court is full, but maybe she can be placed on the wait list if they are recommending inpatient treatment for her. Probation, is there anything else she needs? Yes. All right, is there anything else you need from the court in order to be successful?
No, ma'am.
Judge, she'd like to know, how much longer or how long she would be waiting for that TAP evaluation since you ordered it in custody.
Yes. Up to 2 weeks.
Okay, thank you.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so here's the thing. Those 3 children Those are your children. It's not the grandparents' child. The grandparents are just supposed to be grandparents to children. They're not supposed to be raising more children, which is raising your children. You cannot have children and then tell them to go to Travis Park and say, you're on your own. And there is no reason a child should be able to get out of your house and you not know about it, and they're that age. So many things could have happened to your child when they got out of the house. Could have been hit by a car. And guess what? People can't see children that age because they're tiny and they're small. Somebody could have picked them up. And guess what? There's a reason we have indecency with a child cases in this court. Anything could have happened to your child. And when you're using drugs and you're pregnant, whatever you're using, your child is using too. So if you don't think a baby should be smoking a cigarette, you shouldn't be smoking a cigarette, because guess what? When you're carrying a child and you're smoking a cigarette, your babies are smoking a cigarette. If you don't think a child should be doing alcohol, when you're drinking alcohol, your baby's drinking alcohol. You're going to have to start making better choices.
2 defendants, 1 judge, and 2 sentences that both came with the same underlying message. You still have a chance, but you're running out of them fast. The first defendant, a 20-year-old with 3 prior revocation motions, walked in thinking today was routine and walked out in handcuffs headed to an intensive supervision facility. He's been warned about prison more than once. The court gave him one last structured alternative. What he does with it will determine the next several years of his life. The second defendant faced a felony conviction that could have sent her directly to state jail. Instead, she received a suspended sentence with 4 years of probation carrying some of the strictest conditions this judge could attach: parenting classes, drug treatment, employment requirements, a ban on home health care work, and a genuine conversation about what her children's future actually needs from her right now. What stands out in both cases is how this judge works. She doesn't just rule. She explains, she asks personal questions, she connects legal decisions to real life in language that lands. And when she needs to be firm, there is no hesitation in her voice at all. The courtroom is often thought of as cold and procedural. This hearing showed something different. Both of these people left with an outcome that was shaped around who they actually are, not just what they did. Now I want to hear from you. Do you think the judge handled both cases the right way? Should she have been harder on the first defendant after 3 violations? Or is ISF the smarter call? Drop your thoughts in the comments below. And if you want more real courtroom breakdowns like this one, hit subscribe and turn on notifications. New cases go up every week, and trust me, they only get more intense from here.
You understand?
Yes, ma'am.
Good luck to you.
Thank you.